Okay, Mike, thank you for meeting with me here today. So I've heard that today there was quite a interesting announcement. My understanding is there was a First Nations challenge to some issue around COVID secrecy. I'm wondering if you can tell us a little bit about that and what your involvement was in that project.
Yeah, sure. So my involvement with this work is in my capacity as the president of the BC Freedom of Information and Privacy Association, and BC FIPA, along with the BC CLA and a number of other civil society groups and supporters, have signed on in support of this application. The application itself is brought by three First Nations in BC, Heiltsuk, Sikhoten, and Nutchinut. And it is in relation to ongoing requests that they've had with the BC government for access to proximate case data about COVID-19. So we're not talking about personal information about individual people.
So
we're not saying that if I get COVID, post it, but yeah.
So explain what is proximate. What does that mean? Proximate data.
Well, so the idea is that the nations want to be able to take the lead role in governing their own response to COVID in terms of protecting their communities, and they're particularly interested in protecting vulnerable elders. And one of the resources they need to do that is information about people who are traveling through or have recently traveled through their territory that have COVID. And it's not just in terms of traveling through territory. Some of the nations are accessible by, like ferries or highway corridors, where, if you have cases that are that the government knows about, all they're looking for is information about the location of cases. So that if, for example, we know that there were two cases here that are prospective or confirmed COVID from, let's say, a week ago, that the First Nation can actually take some initiative. That could be things like doing their own contact tracing. They could be, posting bulletins. They could even do something as significant as initiating lockdown or restricting access, those kinds of things.
So is that to suggest until now, First Nations have really been pushed back in terms of their own agency in dealing with the pandemic? Are they actually having a kind of a backseat?
Yeah, I mean, the government, I think, has taken a fairly one-size-fits-all approach in terms of the release of COVID data. So we have, the daily briefings, which are really detailed, right? But they are also not specific in terms of location. This has been an issue, since the very early days of the pandemic. In general, but for First Nations in particular, the argument has been that there is an obligation for the BC governments, and this comes actually under the Declaration of Rights of Indigenous Peoples, DRIPA, to enact laws and to ensure that the BC existing laws are modified in such a way that they facilitate self-government. Mm-hmm. So what the First Nations in this case are saying is, well, we don't want you just to tell us after the fact that we should be doing these things. We want to have the information that we need to make those determinations ourselves. Mm-hmm. And I'm obviously not speaking on their behalf. That's the argument they're putting forward.
So I guess you're saying it is significant that this request is coming from First Nations, which is different than, say, a request for the similar information from, say, parents, and how is that different? Maybe you can expand.
It's a great question. And I think this is one of the more complex parts of the case. So let me just really quickly unpack the grounds on which the argument is, or the challenge is being made. There's two grounds. Sure. So one is under Section 25, 1A of the Freedom of Information and Protection of Privacy Act, which is basically, it's called the public interest paramountcy principle. And basically it says that notwithstanding all the reasons that governments can usually keep information confidential, mm-hmm. if there is a genuine public interest, specifically if information pertains to a risk to health and safety or to the environment, there's a duty, positive duty to disclose that information actually proactively. Mm-hmm. And so the part of the argument here is that this is information about a health risk, absolutely. Mm-hmm. It is time sensitive. There's a temporal urgency to it. Government has the information. First Nations need the information. So there's one argument under Section 25. I think the facts of that argument are really strong.
Yeah, so there's it's absolutely also, in the interest of the public to have it disclosed, yes.
Yeah, absolutely. But there is a specific angle to this too, because it's not that there's a request for this information to be published. And this is a big distinction. Normally when I work on freedom of information cases, what I'm looking for is secret information to be made public facing. But what they're looking for here is a government-to-government transfer of information, which is something that governments do all the time anyways, right? There's transfer between, the province, other provinces, federal government and provinces. And they're saying, well, we're sovereign, we're governments, and we need access to this information that's collected by the BC government to be able to do governance. So there would be checks and balances put in terms of protecting the confidentiality of information. Which makes this quite distinct from just your standard request for access. The other thing that makes it distinct is that there's the citation of the DRIPA as a factor here. It's the Declaration of Rights of Indigenous Peoples, because the BC government has made that commitment to the UN Declaration, and this is the first time to my knowledge, and I think I'm pretty right about this. It's the first time that I've seen a public interest access to information challenge also citing and engaging with this, because that does say that there are special requirements when dealing with Indigenous governments, that there should be, I think, a different approach. And also, a kind of additional factor, all of this is couched in the context, which is a colonial context where information has been extracted from Indigenous peoples, used by governments. There's been, the challenges associated with things like land claims, for example, go on for years, getting access to the kinds of records that are necessary to make those things. So there's this long-standing information, colonialism, paternalism vis-a-vis Canadian governments and Indigenous peoples. And there's also the history of pandemics and plague and sickness in Indigenous communities, where, I think there's this added really, really legitimate argument that says if there's information that can help to protect communities, it really is incumbent to make that happen.
Yeah, so from what you've said, it sounds like it's really equal, but perhaps even more so about this question of First Nation sovereignty, right? These requests are actually a way of enacting or expressing or articulating sovereignty in the form of an information request, but it actually is very much an act of sovereignty to demand this COVID-19 data to be revealed, right?
Yeah, absolutely.
To legitimate leaders, if you will, of a community.
And that's really important. When cases come to FIPA or to me, sometimes people are starting to look for information, so they want help with filing requests and so on. They're running into challenges with that, which is perfectly reasonable and legitimate to face challenges because the law is pretty tricky. But in this case, they had, since the very start of summer, the nations had been looking to get the government to sit down and have kind of a nation-to-nation conversation about how to make this work. Yes. They were very much interested in negotiation, facilitation. Obviously, it would involve developing some practices because this is new, uncharted territory. But that's also what we're doing with COVID in general, right? So in that sense, it's kind of part of the norm, right? We are trying to make this up as we go. And the government did come to the table a couple times, but was just refused to shift its general approach to information control.
Mm-hmm. So what do you think are the next steps? What do you think will happen next? Not that you have a magic ball, but what do you think will be the next things that will happen arising or coming out of this request?
So and it's a challenge at this point. So it's past the request stage. But so Office of the Information and Privacy Commissioner has already issued a public statement acknowledging receipt of the request and that they're going to focus on this and investigate. And that's good. Hopefully that means it's going to be expedited. But even then, I'm expecting that process may take months, usually does. And it's not, there's lots of processes that really drag their feet. These ones don't, but they still take a while because there's representations and analysis and arguments.
But so wouldn't months make this whole thing moot because you're trying to figure out contact tracing, right? You want to know you want to know important and kind of constantly changing medical information, right, around the spread of the pandemic.
Yeah, it's not going to make it moot in the sense that it will set a precedent. And if the OIPC does find that there is a Section 25 argument or a DRIPA argument, which would be amazing on this, for the release of the information, then the government can't say we still don't want to. That's an order at that point. But the big concern though is if it takes months, people will actually die because of this.
Yes.
Like this is something that when we were crafting with BCCLA, when all the other groups that were involved in this, when we were crafting our kind of public presentations on this, it's one of the points we really wanted to emphasize is like, this is really a matter of life and death. And in a pandemic, days can mean lives.
Yeah.
and so what my real hope is in terms of a next step is that the government sees this action and sees the mobilization around it, right? The public interest on this as a good reason to reconsider. And hopefully they, if they come to the table and they say, okay, tell you what, we'll negotiate these kinds of information sharing relationships. And then it turns out that the OIPC complaint is academically interesting, but not necessary to get the information. I'll be very happy if that's the case. That would be ideal. And they could do that next week. They could say, you know what, we're gonna do this, and it may take us a month to do it, but we're gonna do this and let's work on it.
Yes.
That would be the biggest victory. As someone who's kind of interested in the law and the rights issues on this, I think there is also this really interesting possibility that the Information Commissioner is going to have something to say about the DRIPA and how it relates to Indigenous information rights.
Oh, that would be interesting. Yeah.
And that would be precedent setting, because it would open the door for a whole bunch of other conversations about Indigenous access to government information.
Wow. Okay, well, let's leave it there, Mike. Thank you so much for your time and also for this amazing work. Keep up the good work. Thank you so much. Okay. All right. Take care.